Hello everyone, I'm Anuj Nakade and you're watching Live Law. You all know about the Bihar Caste survey and the petitions in the Supreme Court challenging its constitutionality. Yesterday, the court adjourned the matter to be heard in October, despite the contention of the petitioners that the petitions against the survey may become infructuous by then. Let us understand the background of the case, and it might help us understand what happened in the court yesterday. The Nitish Kumar-led Bihar government started a caste-based survey in January of this year in order to digitally compile data on each family from the panchayat to district level. This was done through a mobile application. Soon, the constitutionality of the caste survey was challenged before the Patna High Court. In May of this year, the Patna High Court stayed the caste survey, and then last month, in August, the Patna High Court delivered its judgment on the issue and dismissed the petitions against the survey. The court said in its judgment that the exercise of caste-based survey is perfectly valid and initiated with due competence. The High Court concluded in its judgment that the state's contention saying that the purpose of the survey was to identify other backward classes and socially and economically backward classes, scheduled castes and scheduled tribes, with the aim of uplifting them and ensuring equal opportunities for them, which cannot be brushed aside. The court also stated that the Bihar government is competent to conduct this survey as any affirmative action under Article 16 of the Constitution or beneficial scheme or law under Article 15, and that such scheme can be designated and implemented only after the collection of relevant data about the social, economic and educational standing of various communities. Soon after, several petitions were filed in the Supreme Court challenging the decision of the Patna High Court. Among other things, the petitioners have also argued before the Supreme Court that the caste survey being carried out by the Bihar government amounts to a census, and this kind of census can only be conducted by the union government according to entry 69 of the Union List in the 7th schedule of the Constitution, read with the provisions of the Census Act. For context, the 7th schedule of the Constitution and Article 246 of the Constitution deals with the division of powers and functions of the union and state governments. List 1 or the Union List specifies the issues the union government has power over. State List or List 2 specifies the issues the state governments have power over in their state. And List 3, the concurrent list, is a list of issues both the union and the state government can make laws about. The petitioner insists that the Patna High Court dismiss the writ petition without taking into consideration the fact that the state government is not competent in the law to notify a caste-based survey. Another petition against the survey, filed by a non-government organization named Youth for Equality, has challenged the Patna High Court's verdict on the ground that it is contrary to the law laid down on personal data collection by the Supreme Court in K. Puttaswamy v. Union of India. Our regular viewers will be aware of this judgment, as we've discussed it on several occasions. K. Puttaswamy v. Union of India is a 2017 judgment where the Constitution Bench of the Supreme Court held that the right to privacy is a fundamental right under Article 21 of the Constitution. While hearing the matter in August last month, the Supreme Court refused to stay the survey and has since on multiple occasions reiterated its stance against issuing stay orders in the absence of a prima facie case. In the last hearing, the Solicitor General of India, Tushar Mehta, sought the court's permission to file an affidavit in the petition to place on record the central government's views on the legal position in this matter. He also clarified that the centre was neither opposing nor supporting the petitions filed about the caste survey. The central government then filed two affidavits in quick succession. The first affidavit stated that no entity other than the central government had the right to conduct a census or any action akin to a census. This statement provoked a strong political reaction. Very soon after, the first affidavit was retracted and the second affidavit was placed on record by the government. This affidavit clarified that this statement was included in the earlier affidavit accidentally. The second affidavit, just like the first one, has argued that the census is a process governed by the Census Act, and the Census Act was enacted using powers under Entry 69, List 1 of the 7th Schedule. The central government has said in its affidavit that this act empowers only the central government to conduct a census. The central government also reiterated its commitment to uplifting the people belonging to scheduled castes, scheduled tribes, socially and educationally backward classes, and other backward classes in accordance with the Constitution. Apart from this, Senior Advocate C.S. Vaidyanathan, appearing for the NGO Youth for Equality, argued that the ruling on the fundamental right to privacy in the K. Puttaswamy necessitates a just fair and reasonable law regarding personal data. This law must additionally stand the test of proportionality and having a legitimate aim. An executive order of the government therefore cannot take place of such a law, even more so when it did not indicate all the reasons for undertaking this exercise. Senior Advocate Vaidyanathan also raised concerns over mandatory disclosure of requirements under this survey. In response, the court had questioned if the right to privacy is at all impacted in this case, as the government does not plan to release individual data but aggregated data. Justice Khanna, who has been hearing the matter, also asked if conducting a caste survey in a state like Bihar, where everyone knows their neighbor's castes, breaches the participants' privacy. Yesterday, Justice Sanjeev Khanna and Justice S.V.N. Bhatti heard the matter again on the 6th of September. The court directed the matter to be relisted on a later date in light of a letter circulated by the Standing Council of the state of Bihar. However, the petitioners opposed this adjournment request. Advocate Yadunandan Bansal, appearing for the petitioner, submitted that the senior advocate Shyam Devan had earlier made a statement in open court that the government would not publish the survey. However, he was interrupted by Justice Khanna, who promptly reminded the council that he was wrong. He reminded the council that Senior Advocate Devan said that the data already is in the public domain. Advocate Bansal, however, said that the petitions will become infructuous if the matter is adjourned to October. Justice Khanna pointed out that the data has already been uploaded and the data is currently being analyzed by the government. The court then adjourned the matter to October 3, informing the councils that that is the earliest available date. And we intend to keep you updated about this case. To get our updates, please subscribe to our channel. To get more details about the case or read the judgment of the Patna High Court in this case, please visit our website at www.livelaw.in. Leave a like if you found the video informative and consider supporting the work we do here by joining our channel as a member for only ₹89 per month. Thank you.